So the MADE Forum is meant to be a space where you can come and share your knowledge and wisdom in the gaming industry, when it comes to the technology industry, any kind of digital entertainment field. So today, we're focusing on workers' rights, benefits, and negotiations. Welcome in, welcome in. And today we have Zach Angulo, who is from Weinberg, Roger, and Rosenfeld, joining us to talk about negotiations, IP rights, and fun stuff like that. So before we get started, how many of you know about workers' rights? You think you know a lot about workers' rights? Yeah? Okay, awesome. How many of us work in games? Or in technology? Oh, nice. Okay, very cool, very cool. Let me hit our slide. Zachary, thanks for joining us. Can you please tell us a bit about your area of expertise?
Sure. So, as you mentioned, I'm an attorney at Weinberg, Roger, and Rosenfeld, and there are three aspects to my individual practice. The first is I represent unions as both general counsel and strategic counsel. I also represent a number of employee benefit plans that are arising under collective bargaining agreements, such as pension plans, health and welfare plans, training plans, and so on. And the third aspect of my practice is nonprofit representation, so institutions that focus on educational and charitable purposes.
Awesome. And what made you go into labor law?
So many years ago, I was a grad student at Northwestern University. I was studying for a degree in history, and the year was 2016 when graduate workers were allowed to unionize at private sector universities like Northwestern. So a few buddies and I decided we're going to organize. And we started a campaign where we were organizing teaching assistants, research assistants, and essentially the whole operation of grad students at that university. They finally won recognition just last year. So that speaks to the length of time that is often required for a successful union campaign to reach its height. But as a result of that campaign, I decided to study labor law. So I switched my career path. I decided to go to law school, and I've been helping workers ever since.
That's awesome. Tell us a little bit about your firm.
Sure. So Weinberg, Roger, and Rosenfeld is a decades-old firm. It's been around in various forms since the 1960s. So it's sort of a product of the new left. And I believe we're the largest, don't quote me on this one, I believe we're the largest union-side firm in the country. We have over 30 attorneys in our staff, both partners and associates. And we have locations right here in Emeryville, like Oakland, East Bay, LA, Las Vegas, Hawaii, and I believe I'm missing one, Sacramento. So we're a pretty large firm, but at the same time, our geographical reach on the West Coast allows us to interact with a whole range of industries.
Awesome. Very cool. Okay, and what kinds of clients do you usually work with, or what kinds of things do you help them with?
Sure. So generally my representation is labor-focused, of course, but in addition to the unions and nonprofit organizations that I represent, I've also counseled workers on an individual basis with issues such as severance agreements and layoff terms, employment discrimination, and I also serve as inside counsel for different administrative offices that unions and their benefit plans have organized to keep their operations running.
Fabulous. So let's define a few terms here. What are severance agreements?
So severance agreements are a kind of contract that does two things, generally. The first thing that it does is it provides some consideration or money to an employee, and the other thing that it does is it provides a general release of claims. So what they're structured to do is, in exchange for severance, the worker will not take action against the company. Sometimes there are non-competition clauses that are rolled into the agreement. Sometimes there are terms that will stipulate what the separation of employment was. Usually it's not a termination. Usually it's what's called a no-fault separation. So in general, that helps or is intended to help the employee find new employment after the separation. There may be confidentiality clauses that are rolled into them as well. And all of these kinds of things that I'm talking about that are rolled into these agreements are viciously litigated right now. So the National Labor Relations Board in the past couple of years has been taking a look at severance agreements and considering whether they violate the National Labor Relations Act. So you'll find overly broad confidentiality provisions that essentially disempower the worker from bringing claims related to their own union organizing, to their own workplace conditions, or even just talking to coworkers about their salaries. So depending on how broad the agreement is, it could really affect a worker's life. In the tech industry specifically, there are provisions that you find related to intellectual property rights or the lack thereof with respect to the worker. And these kinds of provisions are particularly vicious because they often prevent employees from accessing their own portfolios and projects at work. So when they're separated from their employment, they really don't have much to show for to a new employer. So that basic exchange that I'm talking about, the release of claims for the severance pay, that has evolved to include all kinds of other terms that makes the severance agreement a severance agreement. And I just realized I didn't really explain what a general release of claims was. So I'll just very briefly, a general release of claims is a giant paragraph in a contract that says this employee will not sue the company, its officers, its agents, its attorneys, its accountants, personal assistants, anyone associated with the company in any affiliation, with claims that they either know or don't know or suspect they have. So general means extremely broad, and a legal question is whether that should or should not include claims related to workplace rights and organizing.
So speaking of portfolios, can you tell us about IP rights? How does WRR expand workers' rights in tech when it comes to IP?
So those are, I'll take those as two questions. So with respect to intellectual property rights that you see in these contracts, part of the general release of claims is intended to include any dispute over the portfolio that an employee has. And usually the way that that is stipulated in the contract is that that intellectual property belongs to the company. It's to be kept confidential. It cannot be shared by the employee. And it's less true in California now, but those provisions used to include obligations related to non-compete and not being able to compete against the employer for a particular period of time with all of the trade secrets or other knowledge that you've gained at the company. It also made it very difficult for employees to start their own organizations because these kinds of provisions were meant to prevent you from activating the relationships that you would develop in the course of your professional life that you would really need to start a proper business. So that intellectual property clause historically has been a tool to deprive the worker of all of the knowledge and experience that they would need to move on from that job.
Awesome. Agreed. Let's talk a bit about pensions and equity.
Okay.
What are pensions?
Great question. So pensions, I'll start by saying pension law is some of the most boring law you'll ever read. There is a conference that takes place once a year for people who work in retirement plans, and that includes people who administer them, lawyers like me who work on them and represent them, and it's about as exciting as you might think. That being said, there is a very interesting pattern with respect to retirement plans that is decades long and is particularly important to the tech industry here in California. So many years ago, the model was that an employee would have 3 sources or so of retirement income. The first being a pension that was a monthly benefit that accrued over the course of years working with usually 1 or 2 employers. And the second aspect of it was Social Security. And the third was some kind of defined contribution plan, usually known to people as a 401k. So that 3-legged stool, that model of retirement, is what's supposed to drive someone's access to a free life after 65. But the evolution of that has changed significantly and at a faster rate over the years. So, for example, there's a question about whether Social Security will even exist in the near-term future. Defined benefit plans, which is your traditional pension plan, since the 1980s, there's been such a move to reduce the amount of these. So they're very expensive relative to other kinds of retirement plans for companies. And in the 1980s, when private equity firms and other sorts of investors rated companies, their practice involved rating the pension funds. So the idea was you would take over a company. If you've ever seen one of my favorite films, Working Girl, there's some of that in there. When there's a hostile takeover of a company, part of that involves getting rid of the company pension, figuring out a way to release that line item off of the company's budget, and figuring out in what way that could become a source of returns for the new investors. So since the 80s, those defined pension plans have gone away. There's still plenty out there, to be sure. I represent a number of them, but it's not part of the traditional. For us, it's very likely not a source of retirement income if you're a younger person. So that leaves really just one leg of that 3-legged stool, which is a defined contribution plan, the 401k. Now, the interesting thing about the tech industry is that even that is going away. So some companies, particularly startups, won't offer a defined contribution plan, certainly not a defined benefit plan. There's nothing they can really offer in the way of Social Security because that's a government program. But in lieu of providing the 401k, they will provide you with equity in the company instead and say, well, we have this option to purchase stock, or we'll give you shares in this company, and once it's profitable, then you'll get your payout. So that pattern that I'm talking about, that decades-long pattern, has been we're moving from a model where the worker has very little risk for the return. In other words, the old model was if you put in your hours, you'll have a retirement. Then around the 80s and 90s, the model was you'll get at least a certain amount of money from the employer over the course of your work. You may not get a certain calculated benefit that you know in advance, but you'll at least get some kind of sum in a 401k. And now workers are being told, well, we're going to shift the risk of the company onto you so that if the company does not survive, you won't have anything. So we're reaching a point now where, in addition to being asked to survive what is historically unprecedented, at least in recent history, inflation with respect to wages, workers are also being asked to bear the risk of the company's future with respect to their retirement. So there's not much in the way of proposed solutions to that problem for workers. There is, I think, in the Bay Area, a very persuasive narrative that if your company succeeds, you'll be just fine. But when you look at something like the Silicon Valley banking crisis, the fall of these smaller startups, it's very hard to justify.
Definitely. And so what is equity?
So equity refers to your ownership in the business. And the problem with basing your retirement purely on one company's equity is that it's, as I said, very, very risky. And in fact, if you're in a traditional pension plan, or even if you have a 401k that has investments in it, the financially responsible thing that these plans are required to do is to diversify investment. So there's no pension plan or 401k that has just one company invested in it, or even, just equity. Usually there's bonds, there may be commodities or other kinds of assets in it. But when you're given equity in the company in lieu of something like retirement, you're being asked not just to risk your retirement on the company's future, you're being asked to do something that is, in any other context, financially irresponsible.
What do you think changed pensions and retirement over the years? What factors?
I'm sorry, can you repeat that?
What factors do you think changed pensions and retirement over the years?
There's been a dramatic change in the law related to these different retirement plans, particularly after 2020. So one thing that we saw in our office that we had to deal with rather frequently was the problem of creating liquidity for working people during the pandemic. So what that means in normal human terms is workers who had saved up a lot of money in their 401k, lost their jobs. There were layoffs in that time across industries. And the question was, how do we get these workers to access the retirement income that they have in their accounts now, as opposed to when they're 60 or 62, 65. So one thing that's changed dramatically in the few years is the ability of workers to take out loans against their own 401ks, the ability to get early distributions without any tax penalties, and accessing money that they otherwise would not have access to for a very long time. Now, I see two issues with that. The first is even if they're accessing money that they have saved up for retirement, they're using it to pay expenses now instead of keeping it in the account to grow by the time they're ready to retire. So they're losing out on principal that they would normally want to be invested. So that way the fund keeps growing. So that means that what we saw in 2020 was a big loss to the different 401k funds that these workers had been saving up for. The second part of that is with the rise of inflation, which has started to tail off a bit. A lot of that money that was taken out was used to pay prices that workers didn't have to pay before. So it's becoming more expensive to retire, and the money that's available to retire is often used on expenses other than retirement. So, in a way, these workers are being asked to take their retirement funds to pay expenses that they have now, usually because their wages aren't high enough to cover their actual expenses. So, it's kind of a change that we're seeing across industries, and that I think can really only be resolved by organizing.
Yeah, definitely. I think it's a different working world today than it was in the 70s.
Absolutely.
And so how do you think that millennials and Gen Zs will retire differently from baby boomers?
I think the question now is, what model do these newer generations want for their retirement? So the model of going to one company and working there for 25 to 40 years is kind of gone. And certainly there's very little promise of getting a traditional pension benefit out of doing that anyway. So the labor market that millennials and the Zoomers have is one that's very precarious. Folks in those generations tend to move from job to job. It's rare for them to keep a job for 10 years, 20 years. I mean, they're still young. Who knows? That maybe that pattern changes. But as it stands now, there's very little of what I would say the boomer generation had called company loyalty, which is fair, because if a company is not going to invest in your future for retirement, why bother having that loyalty in the first place? So that basic trade is kind of gone. That being said, I do suspect that there is a change in values among these younger generations where they may question whether 65 makes sense as a retirement age to begin with. So what we're seeing with the baby boomers and the generation after them is they don't really want to give up their jobs at 60 or 65. They stay a very, very long time. And the law has adjusted for that, where before, once you hit the age of 70, for example, you were required to take out your money from your 401k account. It's supposed to be distributed, and the assumption was you must be retired by the time you're 70. That age has increased from 70 to 72, and in a few years it's going to increase again, I think, to 74. So you can sort of see the assumptions that are baked into that. That number one, someone's going to live to 74. They may even continue working when they're 74. And they may want to keep their money where it is until they're 74. And with younger generations who are used to money changing pretty quickly, we are the generations of Venmo, for example. We're used to having electronic account access to our bank accounts, and because of that, I don't think that we think in those same terms as the older generations that sort of keep their money where it is and keep it till they're 74, assuming that they're working with the same company. So I would say that, number one, we don't know what retirement is going to even look like for millennials and Zoomers. It's an open question about whether Social Security is even around. There's a question of what healthcare. So retiree healthcare has been changing for years as well. We're not sure where these younger generations are going to get their health insurance or health coverage from. And we're certainly not sure of what kind of retirement benefit they'll actually have, because if there is no defined benefit pension plan, it's not going to look like a check you get once a month from the company you work for 30 years. If 401ks become less popular than equity, then you're not going to see as many defined contribution payouts. And if companies start moving to a model that's total equity based, then some people are going to have a great deal of cash on hand, and others aren't going to have much at all. So we really are at a stage where I think the law is, it has to change to account for these new preferences and the new reality that millennials and Gen Z live under.
Right. I think I know what I think about this, but what do you think? What is better, pensions or equity?
I am a big advocate of the traditional pension model. I do think that what needs to be adjusted is how we think about what's called in the pension world reciprocity. So, to give an example, in the construction industry, if a worker is, let's say, a laborer working on a construction site for a company in Nevada and then works on a construction project in California for a different employer, they may have two separate pension benefits accruing at the same time from the different employers. And what reciprocity does is it's a legal way to say, look, we know that you don't want to have two smaller pension credits at two different funds. Let's find a way to bring all those pension credits and years that you're working to one fund, so you get one check. And because these younger generations move from company to company, if there's going to be any kind of pension benefit that they fight for, then there has to be an even broader and more flexible reciprocity to receive that pension in the first place. That being said, there are other models out there. For example, I think our generation will have to consider what a national pension would look like, so publicly provided pension. There, on a very small legislative level, there's been some consideration of what changes can be made to Social Security, not just to make it more sustainable, but to turn it into what would essentially be a larger pension system. So that would be one way that takes away the reciprocity question entirely, because then you just have a federal plan instead that does something that employers don't want to do anyway, which is to administer the pension plan. Another thing to consider about this is how do we account for, instead of an accrual of pension credits or years of service, what do we do in cases where a worker just wants to cash out? So, it may be the case that a worker doesn't want to just accrue hours with employers year after year and have money locked up till they're 65. They may want the ability to cash out without any kind of tax penalty. So, all this to say, I don't know what the system's going to look like, but whatever we have in law right now is not thinking about millennials or Gen Z's preferences.
Agreed. So equity is still not as good as a pension.
Correct.
Great. Okay. So let's talk a little bit about layoffs and unions. Sorry about that. If I am laid off as a tech worker, what rights do I have while recovering?
Great question. So the main thing about layoffs is figuring out whether it is a layoff under a number of different laws. So there's a federal law called the WARN Act, and California has its own statute called the WARN Act. And the object of these laws is to make sure that workers know well in advance when a layoff is going to happen. And in the state of California, there are pretty big penalties in addition to back pay remedies for the worker when a company fails to provide the required notice, which could be from 60 to 90 days. Now, the issue with that, if you recall from earlier, about 5 minutes ago or 10 minutes ago, usually when there's a layoff, an employee signs a severance agreement. And in that severance agreement, there's a confidentiality clause and a general release of claims. So if a company decided to lay off its workforce, but it provided its workers with these severance agreements, the question is, who's going to find out that there is a violation of either WARN Act? And that's the kind of game that a lot of these companies are playing. So there's a confidentiality clause that would prevent the worker from talking about the layoff, the circumstance. There's a stipulation in the agreement that says it was a no-fault separation, which is not the word layoff. And there's a release of claims. So, at first glance, the worker may think, well, even if I could talk about it, I certainly can't do anything about it. So what our office has done is we've tried to find ways to break or release workers from these agreements so that way it can be determined whether there actually was a layoff. And if there was, and they didn't receive the required notice, they may be entitled to back pay. And what's particularly nasty about these situations is there are also separation agreements that specify that the separation in employment was a resignation. And if that worker wanted to apply for unemployment insurance, in some states they would not be able to get it because they would have left through their own fault. That was stipulated in the contract. So that could be a very scary scenario. Another big topic during a layoff is where is the worker going to get their health care? So in this country, our health care generally comes from our employers. And if you are separated from your employment, the first thing that some folks may think of is, oh my God, I have these medical expenses, or I have this prescription medication. How am I going to cover the cost if I no longer have access to the company plan? And there's a federal law called COBRA. If you've ever heard of COBRA coverage, that is your right to continued coverage under your old employer-sponsored health plan after you've separated from employment. Now, the thing with that law is it doesn't guarantee it on the same cost. So if you're paying a premium for your health insurance when you're employed, after your employment you pay what's called the COBRA premium rate, which is generally a lot more expensive than what you might have been paying otherwise during your employment. So you may have the right to continue your health coverage, but it's going to be more expensive. Now, the state of California in particular has been trying to find ways to subsidize COBRA premiums, which is great. They've tried to build up an individual coverage market to help people who are separated from employment and just can't afford the COBRA rate so that they can find alternative coverage in the meantime. And that's something that the state ought to be doing, because in this state we're required to have health insurance and to be covered. Otherwise we're subject to a tax penalty. So, there's at least some movement to fill in that gap for laid off workers or workers separated from their employment. Now, as far as labor rights go, when you're laid off, so in the past couple years, at certain tech companies, there's been a move to unionize, and also a move to return folks to the office from remote work. And our office, just with our experience in the past 2 years, we've concluded that these two things are actually related. So when there is a company that faces a union campaign, that's often when we see a move back to the office. In fact, a prominent example of that is actually Grindr. Grindr had a union, still does, has a union campaign that recently won an election, a union election, and just a few days later they demanded that everyone come back to the office, even though that company has advertised itself as a remote-first workforce and has done so for years. So these things are related. They did have a round of layoffs following the rise of that campaign. And the National Labor Relations Board has responded in those scenarios to say these separation agreements that workers are forced to sign or even just offered when they're laid off and there's an active union campaign going on, they may have rights that this agreement tries to take away but actually can't take away. And those are many of the things that I've talked about already. So, they still have a right to file an unfair labor practice charge against their employer, even if there's a broad confidentiality agreement. They still have the right to talk about basic work conditions with administrative agencies like the National Labor Relations Board if they suspect that those conditions are violations of federal law. So the question really becomes, how do we get these workers to understand that when they're laid off, they still have these protected rights, even if it appears that the agreement they signed takes those rights away?
Wow. And can a union collectively negotiate better severance terms?
Absolutely. And there are two ways that could really happen. So in your normal severance agreement, the arrangement for the severance is individually negotiated. And I'm using the word negotiated very loosely because in practice, the worker is usually told you're going to be, your termination will be on such and such date. Maybe it's 2 days away, and this deal, for the severance, you can either take it or leave it. That's what happens in practice. But they're individually negotiated. Very, very loose phrasing with that. Now, another model that companies have used to offer severance is a severance benefit plan. And this is a separate way to offer a severance. So, in the first example, the company makes an offer to the individual employee. The employee can either say, hey, I want a higher or better package, or I want to pencil the severance agreement and hand it back. In the second case, where there's a severance benefit plan, the employer has a written benefit plan in the same way they would have a written 401k plan or health plan or retirement plan that provides in advance all the terms. So it would specify a formula for how the severance benefit is calculated. It specify the contract language that the worker would have to agree to get the severance. And because it's an employee benefit plan under federal law, that actually cannot be negotiated. So an individual worker cannot come in and say, hey, I want to change the terms of the benefit plan. The employer is actually prohibited by law from negotiating that any further. So what collective bargaining does, when you have a union negotiating this, workers can use their collective voice to either create a general severance plan that is in the union contract, or they can negotiate to have a new severance benefit plan that the workers and the management administer and calculate together. So, that helps solve the problem of leverage on the one side, and it also provides more transparency into the process behind the calculation in terms of the severance benefit in the second case. So I have not seen yet a union contract that specifies that kind of severance arrangement. There's no reason in law why it couldn't. You do find, especially in manufacturing, union contracts that specify some kinds of payments and even retraining of workers in the event of a layoff. But of course, a severance is something that's a bit more specific than that.
Awesome. So I hear that Weinberg, Roger, and Rosenfeld are going to be offering some free online webinars. Tell us about your webinars.
Yes. So we're putting together what I'm hoping to be a monthly webinar series on workers' rights, particularly in the wake of the layoffs that we've been seeing in Northern California. We do intend to have an explainer on the WARN Act and fringe benefits. And we're also focused on changes to privacy law in the workplace and what can be done to protect workers from surveillance as employers bring people back into the office or beef up the kinds of software that they use to monitor employees who work remotely.
It's exciting. Okay, cool. How do we stay in the loop?
So we do have a form. There is a Google form that I put together. there's a QR code up there on the screen. Code. Yeah, that'll take you to the Google form. We also have a broader newsletter that we publish from time to time. If you go to unioncouncil.net and scroll down to the bottom of the first page, there's a sign up for our newsletter. So when there are changes to law or there are big cases that have been decided, we put all that together in a format that our clients and really anyone can use to stay abreast of all the changes.
Awesome. So for the audience, if you are going to join a webinar on workers' rights, what kinds of stuff might you want to learn about? Any ideas? Like what kinds of topics? You want to shout out? Medical stuff, severance pay. Negotiating better severance pay.
How you can do that,
yeah,
for individuals or groups of people.
Mm-hmm. Absolutely. Cool.
So I do have a small note on that, which is before the past year, if you were offered a severance agreement and you were below, I believe, the age of 40 or 45, you were not entitled to a consideration period to think about whether you wanted to accept the agreement. But because of a change to California law, you're required to be given at least 5 days, which is not a lot, but it does show that this is on the mind of the California legislature. And this really puts the foot in the door to better legislation to even out the bargaining power for those severance agreements.
That's good to know. Does anyone have any questions? Q&A. Going. Yes, go ahead.
Hello. Is your firm working on any class actions right now? Can you talk about those? What does that look like for you as an attorney?
So what I can say is we do have a litigation team that does a lot of class action work, generally related to wage and hour violations. That being said, we are dipping our toe in privacy law and figuring out what class actions in the workplace privacy law space look like. As you might know, the California Constitution grants a right to privacy, which our federal Constitution does not. And in the past few years, particularly after the pandemic, the legislature has been looking at ways to beef up that protection in statute. So formerly, when businesses had what was essentially an unfettered right to monitor you in the workplace, workers now have some ways to reclaim that privacy in the workplace again. And so our firm is exploring ways to incentivize companies to change their practices by initiating class actions against them.
Another question over here.
This one might be a little more out there, but you guys hear much about this lawsuit where Amazon and SpaceX are just trying to say NLRB doesn't have a right to exist and will actually go anywhere?
Is it going to go anywhere? Well, with the Supreme Court, anything is possible except workers' rights. That's as much as I can say about that particular case. But here's an interesting question. So we all know, in my space at least, we know the firms that a company like Amazon hires to make these really stupid arguments. And one thing that we've begun asking ourselves is, if the National Labor Relations Act requires you as an employer to bargain in good faith, but you hire a lawyer who says that that law requiring you to do so is unconstitutional, could you ever really comply with that law? So our argument now is, if there's a union campaign and to fight that campaign, the employer hires a firm willing to make that kind of argument, then there's no way they can proceed in good faith. And there's probably an unfair labor practice we can file based on that theory. So we're trying to find creative ways to resist and fight back while that legal question continues to pend. I will say, though, that the fact that this argument can be made today really shows that we've rolled back workers' rights to about the 1930s in some ways. And there's another case that has not gotten as much press. It was already decided by the Supreme Court last year, and it concerned whether a union was liable for property loss and damages when there's a work stoppage. So there was a concrete company that mixes concrete, and there was a union that went on strike. So all the concrete in those trucks hardened, and it was not used. And the Supreme Court has indicated that it's open to taking certain disputes out of the National Labor Relations Act and bringing them to just property disputes under state law, which is very scary, because that means that when a union goes on strike, which is a primary weapon that it has, the basis of which is forcing the company to lose money, this kind of argument could help employers gain the money back from the union directly if they file under property damage. So the fact that the Supreme Court is willing to consider that scares me about this idea that the National Labor Relations Act is unconstitutional.
Go ahead.
At Google, there's a Alphabet Workers Union that I think they call themselves something like a minority union. They're not like a traditional union. So I'm just curious, if you have any thoughts on that kind of unionizing model where maybe you can't get the numbers to do a traditional union, but you're trying these ways to organize and have some kind of workers' rights, and like maybe what are the trade-offs of the two different approaches legally?
That is a great question, and one that organizers and lawyers and union officers are debating and have been debating for a number of years now. So in European labor law, there is a principle that as a union gets bigger and represents more workers and a larger proportion of workers in a business, they get more rights. And then once they're a majority union, they become the exclusive bargaining rep, and they get all the really strong rights that are associated with having a union. Our country doesn't do it that way, but I think that what the logic of a micro unit is doing and showing is that there are ways to try to make that gradation work in some way. Google is an interesting case because it uses a lot of contractors. And so there is a joint employer status that the National Labor Relations Board has been considering about Alphabet for some time. And, it's sometimes easier to get representation if you're working just under one of those contractors rather than saying, we're going to represent all employees everywhere, wall to wall in Alphabet. So the benefit of that smaller model is that it gives workers a taste of what the larger union can do. It, at the same time, does not get you as much power as getting the workers on the same page, wall to wall, and being able to put on massive direct actions or calling a work stoppage. One concern that I have about the micro approach is whether it's really giving these organizers and union campaign leaders experience with union governance. So when a union grows to a certain size, it becomes an institution. And it's very hard to govern a union as an executive board of elected union officers. You have to account for disputes between bargaining units. You have to balance out interests in contract negotiations. Generally, as you grow as a union, you're subject to more reporting requirements under federal law that you have to keep up with. All of these are governance questions. And if you're proceeding just with really small campaigns, it's very hard to get the experience you need for the moment when you're actually big. So I think there's some advantages to the micro-unit approach for organizing and getting workers who are not used to having a union, giving them a taste of what collective bargaining can do. At the same time, I think that it's not a model that is meant to replace other kinds of organizing and other ways of thinking about collective bargaining.
Any other questions? Awesome. Okay. Thank you so much for joining us. Thanks everyone for coming. I could talk about this stuff for another hour, but it's dinner time and So thank you so much for coming. Stay tuned by signing up to the Union Council newsletter. We might come back for another MAID forum after GDC. The MAID's going to be really busy with GDC in the next month. So thanks everyone. Until next time.
Thank you.